found that email that's going to make the case the linchpin, the cornerstone of your lawsuit. You're gonna win. You just take this email to your lawyer, and you think that he or she's gonna be able to win the lawsuit for you. Not so fast. The reason why is that just locating the evidence is half the battle. Getting it admitted in court is the other part. If you stumble upon the evidence part and you can't get it in, it's useless. You can get all the evidence you want, but unless your lawyer is able to get it in, it's not you can't use it. It's like it doesn't exist because it doesn't. The record only reflects admissible evidence. And so one way that lawyers try to get it in is the business record exception. So I'm going with the Federal Rules of Evidence 803, but your state also has the rule of evidence too, and it's similar to that. The rule of evidence is that a document is not admissible in court if it's hearsay. So the simple thing to do is, as soon as someone you try to introduce this email, the lawyer on the other side, if he or she is switched on, will make a hearsay exception and be ready to argue it. You or your lawyer will have to make an argument on why there's an exception to hearsay and why this key piece of email comes in. One way people will get it in is 803(6), and this is a business record exception. This is boring. You're going to fall asleep reading it, but just these simple steps. It's A through C. Just make this argument. But lawyers stumble upon it all the time, whether it's a last minute objection and they're dealing with it in front of the judge at trial or through legal briefing before the trial even starts, whatever the style is or the strategy to be employed by your lawyer. They're going to stumble upon it because here's why. Everyone knows that emails are exchanged by between employees. It's a regular thing, but it doesn't mean it's a business record because the business record is a narrow category for documents produced as part of a company's business activity. We're talking about ledgers. We're talking about financial records, balance sheets, and so maybe some type of log. But just because it's an email on a work email address doesn't mean it comes in. Some judges misunderstand and just think, yeah, it's a business exception. It comes in because it's a work email. Yeah, it doesn't work that way. And the appellate court may disagree with it. And so the reason why is that you have to help your lawyer under, explain to the court how business is conducted at your job and how this email communication is part of the conduct of business. So it could be something as simple as I ran the report, I'm sending it to you, and here's the spreadsheet, or here's the link to it. Or it could be a team or Slack message saying, I sent you the information, the report's done. So that's part of a normal business process. And then if you were challenged and they said, hey, you never did your job on time, you can bring this message in because you can explain how work is conducted in your office. And there's a transmittal email or message whenever a certain step in the work process is completed. Okay, back to work.